done. We're about to be live. We're about to be live.
Dylan got jokes today. All right, Dylan.
All right, we're live.
Good afternoon. It is 6th of April, 2021. This is the House Judiciary Committee. We're having a voting session. A lot of these bills are either administration bills or they're bills that came out of subcommittee sessions that happened yesterday. So to that end, they may be straightforward, they may not be. Just stay tuned. It's fun to watch. Senate Bill 75 or 78, Senate Bill 78, Senator Waldstreicher's bill regarding ketamine came out of the Criminal Law Subcommittee. Delegate Moon, can you talk briefly about what the bill does, or do we want to kick it to Claire?
It just, the bill was amended in the Senate to become a data reporting bill for 3 years, starting in 2022. So I think with that, there wasn't any opposition.
All right, is there a motion on the bill?
Move favorable.
Motion for a favorable, is there a second?
Second.
Motion and a second. Any further discussion? Seeing none. The Vice Chair,
Yes.
Delegate Anderson. Was there?
Yes.
Delegate Erican,
Yes.
Bartlett,
Yes.
Hardin,
Yes.
Conaway,
Yes.
Cox,
You actually beat out something.
Yes.
Crutchfield,
Yes.
Yeah, are you ready for the
Deborah
demo?
Davis,
Yes.
Juanita Fisher,
Yes.
Grammer. You're missing Grammer. Griffith,
Aye.
Rachel Jones,
Yes.
Lopez,
Yes.
Malone,
Yes.
McComas,
Yes.
Moon,
Yes.
Shetty,
Yes.
Cham,
Yes.
Ron Watson,
Boom. Yes.
Williams.
Yes.
All right, I think that's 20. Great. Next is this is Senate Bill 86. Oh, it helps to have the right folder in front of me. Senate Bill 86, it makes changes to the mandatory education requirements for people who are incarcerated.
Move favorable.
There's a motion for a favorable. Is there a second?
Second.
And a
Second.
second. Any further discussion regarding Senate Bill 86? This went to subcommittee as well. Delegate Conaway?
Yeah, so it's just the increase in the days from the 120 to the 240, or what else happened with that?
I think that's it. It
That's it.
increases it. Yeah, Delegate Moon, is that right?
That's it. It's to get people to finish their GEDs.
Okay, thank you very much.
Any further questions? Seeing none, we'll roll call. The Vice Chair,
Yes.
Anderson,
Yes.
Erican,
Yes.
Bartlett,
Yes.
Hardin,
Yes.
Conaway,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Deborah Davis,
Yes.
Juanita Fisher,
Yes.
Grammer. All right. Griffith,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
Malone,
Yes.
McComas,
Yes.
Moon,
Yes.
Shetty,
Yes.
Bam,
Yes.
Ron Watson,
Yes.
Williams.
Yes.
That's 20. Senate Bill 109. This went to family law, Delegate Crutchfield. This has to do with confidentiality programs, address confidentiality programs, and the subcommittee voted it out, I believe.
That's correct.
All right.
It's merging the programs together, the requirements of the programs, since they are both. So
All right. Are there any, is there a motion on the bill?
Yes, there's a motion moving it.
All right, for favorable, and then is there, a
Second.
all right, motion is a second. Any further discussion? Seeing none, the vice chair,
Yes.
Anderson,
Yes.
Erican,
Yes.
Bartlett,
Yes.
Carden,
Yes.
Conaway,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Deborah Davis,
Yes.
Juanita Fisher,
Yes.
Grammer's still not here. Griffith,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
Malone,
Yes.
McComas,
Yes.
Moon,
Yes.
Shetty,
Yes.
Cham,
Yes.
Ron Watson,
Yes.
Williams.
Yes.
That's 20. Senator McCray, expungement of, where did we send this to? We sent this to David, I think, to his criminal law. Did you do that?
No.
No, we didn't. All right, so Senate Bill 114. This is an expungement. It addresses the expungement of 16303H and C, I think, of the transportation article. Let me just make sure that that is in fact what we're doing. All right, it does say that if you're charged with a violation, all right, let me take a step back here because I need to get to the, oh, I see, it's of the whole transportation. All right. I am geeking out and being all geeky prosecutor again, because when you're a new prosecutor, you go to district court and you try a lot of these cases as you're learning how to be a prosecutor. 16303 is driving while your license is suspended. It can be suspended for a variety of reasons. But in any case, 16303, under this bill, it would allow someone to expunge a 16303 conviction for driving while suspended. It also makes it clear that if you're charged with driving suspended for a failure to pay a fine, that you still that you have to come to court that it's a must appear ticket as opposed to just a finable ticket. In any case,
That part's technical. That part's
Just outside of Fisher's district.
Delegate
rewording.
Jones, you're on. There you go. Okay. Starting at class.
That part's already in the law and they're just putting it in a different place. But what it's doing on page 7 is it's saying that the subsequent offender penalty under 16303 only applies when a person commits a violation of 16303 within 3 years of a prior conviction.
Honestly, truly, what does, I mean, yeah, that's in fact what it does. And there are people with questions here, so we're shrinking the mandatory here. Delegate Conaway, or not the mandatory, the subsequent offender. Delegate Conaway.
Thank you, Mr. Chairman. So on a license that's suspended for failure to pay child support, the person would have to show up to court and show that they paid the child support, or how would that work?
I think that's already that's a year and $1,000, isn't it? That's still a year and $1,000. I'm going back to that page of the bill. Yeah, that falls under 16303C of the transportation article, and so that is a year and $1,000 fine.
So, but that wouldn't be expungable?
It would be.
It would be expungable.
Or it would
Under
be?
the bill, a conviction for any suspension under 16303 is being added to the expungement tingement that allows expungements for convictions of misdemeanors.
And they would still have to go through the process for getting it expunged from their record.
Right, thank you.
Yeah, with finishing probation and everything else. Delegate Carden?
Thank you, Mr. Chair. Just real quick, do you still have to wait 3 years if it's a conviction before you can apply for expungement?
Yeah.
It's
Yeah,
10. It's 10.
10 years. Okay.
Yeah, because this is a conviction.
Okay. Thank you.
Delegate Cham. Delegate Cham, you're on mute. Try again.
In here. Here we go.
There you go.
So for a person whose license has been revoked, can they not ever get their license back again?
No, they can get their license back. There's a process by which you can get your license back through the MBA. Usually a revocation, and Delegate Anderson, Delegate Cardin, some of the defense attorneys on here can disagree, back me up, do whatever you'd like. It's fun. But having said that, the revocation usually happens because you get the Delegate Malone, because you got too many points. So you got 12 points and your license was revoked. You go through a process with the MVA. You go to basically a driver education course, and then you come out the other side and you get your license back. Delegate Moon.
10 years is a long time, and this bill passed unanimously across the street, so move favorable.
All right, there's a motion for a favorable. Is there a second?
Second.
A second. All right. Seeing no further questions, we'll go to a roll call. The Vice Chair,
Yes.
Delegate Anderson,
Yes.
Erican,
Yes.
Bartlett, my God, Bartlett.
Yes. It's okay.
Oy, Delegate Cardin,
Yes.
Conaway,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Deborah Davis,
Yes.
Juanika Fisher,
Yes.
Grammer, Griffith,
As a committed expungement advocate, yes.
we have this on tape, right? Rachel Jones,
Yes.
Lopez,
Yes.
Malone,
Yes.
McComas,
Yes.
Moon,
Yes.
Shetty,
Yes.
Cham,
Yes.
Warren Watson,
Yes.
Williams,
Yes.
20. All right, the next is a departmental bill. It's to do with the warrant apprehension unit. And I think it transfers it from one agency, transfers the warrant apprehension unit of parole and probation to the intelligence and investigative division within the same department, within the Department of Public Safety and Correctional Services, and it makes conforming technical changes. Could I have a motion on the bill?
Move favorable.
Motion for favorable in a second.
Second.
Any further discussion?
Bill number, please.
118. Any discussion? Seeing none. The Vice Chair,
Yes.
Anderson,
Yes.
Erican,
Yes.
Bartlett,
Yes.
Cardin,
Yes.
Conaway,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Deborah Davis,
Yes.
Juanika Fisher,
Yes.
Grammer, still not here. Griffith,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
Malone,
Yes.
McComas,
Yes.
Moon,
Yes.
Shetty,
Yes.
Cham,
Yes.
Ron Watson,
Yes. Yes.
Nicole Williams.
Yes.
It's 20. All right, this is coming from DJS. It has to do with the deputy secretaries at DJS. This is Senate Bill 146. It's an administration bill. It allows them to appoint 3 deputy secretaries as necessary as opposed to the current 2. Is there a motion on the bill? Motion for favorable. Is there a second?
Second.
All right,
Mr. Chair, I just had a quick question.
go ahead.
Why do they need 3 versus the 2?
It's an interesting question. We have anything from council? Lauren, did you hear anything?
Just looking at the fiscal note, I must have asked DJS, and it says that DJS advises that the bill will align deputy secretary positions with the organizational structure of the department, which is comprised of support services, residential operations, and community operations. And currently, there is an employee performing the duties of the deputy secretary that would be authorized by the bill. So they're reclassifying the position and having this employee be subject to the executive pay plan, but it won't affect the finances of DJS.
Thank you.
Any further questions? We do the motion? I think we did a motion. We'll do it again. Is there a motion on the bill?
Move favorable.
Favorable in a second. All right, great. Any further discussion? Seeing none, the vice chair,
Yes.
Anderson,
Yes.
Arakan,
Yes.
Bartlett,
Yes.
Carden,
Yes.
Conaway,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Deborah Davis,
Yes.
Juanika Fisher,
Yes.
Griffith,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
Malone,
Yes.
McComas,
Yes.
Moon,
Yes.
Shetty,
Yes.
Cham,
Yes.
Ron Watson,
Yes.
Nicole Williams.
Yes.
All right. With 20. All right, this is Senate Bill 267. Did this go through subcommittee?
No.
Oh, this did not go through subcommittee. All right, Lauren, is it Lauren or is it Claire?
It's me. It's Lauren.
Lauren, can you talk about what the bill does, please?
Yes, it repeals the requirement for a local Department of Social Services law enforcement to send the preliminary findings of a child abuse investigation to the state's attorney.
I think we voted this bill out last year, and so this is back again as we amended it. And so that's why I didn't send it to subcommittee. Can I have a motion on the bill?
Move favorable.
A motion for favorable in a second. Any further discussion on the bill? Seeing none. Delegate Cox, there we go.
Sorry, thank you, Mr. Chair. I was trying to get that fake hand up. So the concern that I think some have raised both across the street and also in our committee is the fact that I think we want more transparency and more communications. I know the department or those who came in favor felt like this was not necessary, but I think when you look at the protection that state's attorneys can provide, just another set of eyes to look at the child abuse cases.
Yeah, are you ready for the general election?
Delegate Anderson, yeah. There we go.
So I mean,
Hey,
we're
Delegate.
talking about protecting children, and I think making sure that in the preliminary stages of the investigation, there's another set of eyes, an independent set of eyes is a good thing. So that's why I'll be voting against.
Okay. Is there further discussion? Delegate Arakan.
Thanks, Mr. Chair. I just pulled up the bill from last year, which was HB 670. I don't
Really?
think it. Yeah,
was?
ironically,
That's funny.
yes,
All right, great.
I know. It doesn't look. Oh, I see where it does that. Okay, it removes the within 10 days portion. I thought it did something else though, but maybe that's literally all it does.
I think that's all it does. That's the only bracket I saw.
Yeah, it just re-letters things after that, I guess. Okay.
Yeah.
All right. Yeah, it did pass at least the House unanimously last time, but okay. Thanks for Thanks for letting me think that through out loud.
All right, Delegate McComas?
Thank you, Mr. Chair. I'm just wondering if part of the movement or reason for this is because a lot of the counties now have the child advocacy centers that are sort of the what do I want to say, the clearinghouse for this stuff. And it's a teamwork. You usually have a prosecutor located there, a social worker, a police officer that's been trained in dealing with this. So that's why I think probably that's what's going on.
I think that's what spurred this. I think, and as we recall, when the vice chair brought us to Howard County, we went to one of those centers there in Howard County and learned about that there. And I think this is part of the reason why they were doing this. But is there any further discussion?
Well, I just want to put in a plug. Harford County had the first child advocacy center. That's all.
All right. Any further discussion? Seeing none, we'll take a roll call. The vice chair?
Yes.
Anderson?
Yes.
Arakan?
Yes.
Bartlett?
Yes.
Carden?
Yes.
Conaway?
Yes.
Cox?
No.
Crutchfield?
Yes.
Deborah Davis?
Yes.
Juanita Fisher?
Yes.
Griffith?
Yes.
Rachel Jones?
Yes.
Lopez?
Yes.
Malone?
Yes.
McComas?
Yes.
Moon?
Yes.
Shetty?
Yes.
Cham?
Yes.
Ron Watson?
Yes.
Williams?
Yes.
19. All right, we have three more. Senate Bill 327 went to the Civil Law Subcommittee. Delegate Carden is not in his car yet, or well, he's getting in his car so he can answer this question.
I'm in.
70.
All right. Oh, and I think I missed one. But okay, let's talk about 327, then I'll come back to 270.
All right. 327 is what's called the SAFE Act.
Yes.
It is a bill that creates a new cause of action for at-risk adults and people with disabilities. It was vetted by all the different sections of the Bar Association that are impacted, as well as the who else? Oh, the AARP and other organizations and associations that have this interest in them. We did have to have an amendment, Mr. Chair, which I will explain. The Senate mistakenly, they intended to take out punitive damages, but they did not intend to take out the treble damages, which is the new cause of action, except they by mistake, they deleted the treble actions part of the language. So our subcommittee voted to put that back in, which was the intent of the drafters as well as the intent of all the advocates. Because of that, there's no opposition whatsoever, and everybody is very much in favor of passing this legislation.
All right. So the first things first, we have an amendment. And I think Dylan is going back to his office right now. I do not have the amendment, but there it is. All right, so that replaces the treble damages. That makes people okay with the bill.
Move the amendment.
Motion for the amendment. Is there a second?
Second.
All right. Give people a chance to read. No, that's okay. Give people a chance to read it. And then we'll go to the screen and I'll take a quick vote and give people a couple more seconds. Delegate McComas. Here, you try again. You're muted.
There we go. I was reading the original testimony on the bill that was in the Senate, And I guess some of the folks that were independent insurance companies and brokers and agents were worried about, I guess, possibly getting sued or something. And I just wondered if that issue got resolved because, you know, a lot of times people see shadows and everything, but I was just kind of wondering because there was some chatter about that.
Mr. Chair, can I chime in?
Yes, Delegate Carden.
Thanks. From what I understand, the Bankers Association as well as the different business organizations worked very closely with the bar to make sure that that was all corrected. And from what I understand, there is now no opposition based on those issues in the Senate.
Okay, because so they took care of the insurance people that were concerned then, is what you're saying.
That is my understanding. Holly,
Okay.
do you have any information that's different than that? That's my understanding.
Yep, that's correct.
Okay, all right, yeah, because Bryson Poplin was the lobbyist for him and wrote the letter. And
Bryson is in favor of this. Bryson is in
Okay.
favor of this language.
Okay, all right, just checking. All right, thanks.
All right, thank you very much. Now we can take it down. We have a motion and a second on the amendment. All in favor of the amendment, please raise your hands. It's McComas, Arakan, Cox, Moon, Shetty, Lopez, Conaway, Carden, Cham, Fisher, Watson, Williams, Deborah Davis, Bartlett, Anderson, Griffith, Atterbury, Crutchfield, and Live Long and Prosper Malone. Anybody opposed? That was too gratuitous. All right, anybody opposed? Seeing none in opposition, the amendment's adopted. We're now on the bill as
Favorable.
motion for a favorable answer and a second. Any further discussion on the bill as amended? Seeing none. The Vice Chair?
Yes.
Anderson,
Yes.
Arakan,
Yes.
Bartlett,
Yes.
Carden,
Yes.
Conaway,
Yes.
Cox,
Yeah, yes, pardon me.
Crutchfield,
Yes.
Deborah Davis,
Yes.
Juanika Fisher,
Yes.
Grammer is still not with us. Griffith,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
Malone,
Yes.
McComas,
Yes.
Moon,
Yes.
Shetty,
Yes.
Cham,
Yes.
Watson,
Ron Watson, yes.
Williams.
Yes.
All right, that's 20. I get it right about 60% of the time. Now, what are you gonna do? Senate Bill 270 now went to the Criminal Law Subcommittee, has to do with indecent exposure. I don't believe there are amendments. Straight favorable, is that right, Delegate Moon?
Correct. The bill, as it was passed in the Senate, clarifies that the existing crime of indecent exposure includes the behavior of touching yourself through your clothes, even if your genitalia is not exposed. And the impetus for it is heavily about public transit encounters that this has happened, and apparently our neighboring jurisdictions on WMATA have this clearly in their indecent exposure law, but not in Maryland. And so there was a letter from WMATA asking us to include this so that they would have the ability to arrest if people did this.
All right, Delegate Arakan.
I just want to clarify, it's not just touching yourself, it's masturbating. So,
Yes, okay, there's the language, thank you.
Is Delegate Juanika Fisher.
It's very strange to talk about this bill, Mr. Chair, but I think for the greater committee, I think the subcommittee had a discussion about, when something is not being seen, it's hard to know what is occurring. And with this bill, we will be, leaning on law enforcement and our prosecutors to determine when that sort of touching should be prosecuted under this law as we're expanding the definition versus not. I mean, folks were talking about, an individual who might have a mental disability or something like that, and they're doing something that is highly inappropriate. But to one person, it might look like masturbating. To another person, it's inappropriate behavior. And so it was favorable, but there was a robust discussion of, in this bill, we will be leaning on law enforcement and prosecutors to really determine when to use it, as things like that do happen. But there can be more to the story than one would know. So I just want to say that for the greater good of the whole committee. Thank you, Mr. Chair.
Okay. Delegate Cardin, then Delegate Conaway.
Thank you, Mr. Mayor. And just to kind of follow up on what Delegate Fisher was saying, we did pass this favorably, and I think it was relatively unanimous. It was unanimous. However, the discussion, and I brought this up, and I'll say it again. It's very uncomfortable to say, but if you have, whether it be prosecutors or police officers who want to be who want to use this as a sword instead of and to try and be somewhat harassing an individual by trying to charge them with these kinds of charges, even though their behavior could be inappropriate, but is not necessarily rise to the level of indecent exposure or masturbation, but it could be construed to such a degree. That could be a problem, and I think we ought to keep an eye on it and see if there are any anecdotal stories, because I would be concerned that this could be used incorrectly, and we leave up to the discretion of the police and the prosecutors to make sure that they're using it in a functional way.
Right. Delegate Conaway, then Delegate Ron Watson.
Thank you, Mr. Chairman. Question, how would this apply to a juvenile?
This indecent exposure still applies to a juvenile. They would be charged as a juvenile found delinquent in the juvenile system.
Okay, thank you.
Delegate Ron Watson.
Yeah, it just seems to me that, and I know how we voted in committee, but it seems like this could be extremely subjective. And this is the committee where we talk about rough stuff, but there are a lot of men who make informal adjustments. And I don't think that I think there leaves the possibility that things could be misconstrued and used against folks unnecessarily. So I'm kind of uncomfortable about this bill, and I'll be voting against it. Thanks.
All right. Delegate Arakan, then Delegate Cham.
I just want to remind everyone that the prosecution would have to prove beyond a reasonable doubt that the person was masturbating, not touching themselves, not adjusting, not moving their bra, masturbating in public. I really hope not to see any unfavorables on this bill. It's about masturbating, not moving your underwear or any of that. Like, they'd have to prove that there was masturbating happening.
How would they do that with clothes on?
There would be video evidence of the person, which is, I'm sure we can all accept, there would be repeated movements.
Delegate Cham.
Thank you, Chair. So I can lay in a little bit of my special ed expertise to this. We have something in special ed called operationally defining a behavior. So, which means we define it in a way where the words and the description of that behavior are so much so that when 50 people see someone engaging in that behavior, they can look back at the definition of it and say, yep, clearly this person is doing whatever the behavior is. So when I look at the definition of indecent exposure, it does kind of lend itself to some subjectivity because it says the person is engaging in masturbation in public. Well, what is masturbation? How is that operationally defined so that when 50 people saw it, they can say, yep, based on the definition, that is indecent exposure. So I don't know if we need some language to tighten that up. I mean, we're all adults here, to really define what it looks like, so that if someone does it, there's not going to be any question whether they engage in indecent exposure or not, because the definition and the law is very explicitly defines it.
Delegate Juanita Fisher.
Thank you, Mr. Chair. I wanted to respond to Delegate Cham. I agree. I think that subjectivity is there. This bill originated from the fact that our law is different from DC and Virginia. And so when they were prosecuting metro incidents and the metro car would come to the Maryland side, they were unable to go forward because ours does not include masturbation. I do agree with you. I think what is masturbation and that spectrum of what's happening under someone's clothes is that I think is vast. But again, it would have to be the reason why I did vote favorable in the subcommittee is, you know, at some point I had to have faith in our law enforcement and our prosecutors to go forward on things that are obviously inappropriate, and that they feel like through to a judge and a jury that they would find that to be masturbation. So that's where the bill came from, and I think Maryland has stood alone in that, because it is very subjective, right? So ours is always an exposure of like without the clothes on. So I wanted to explain why I voted in favor, but also why I see those concerns, and I think that's why Maryland has been behind DC and Virginia, and why our law is different and where this came from.
Move the previous question.
It's a motion for the previous question. We'll move the previous question. The motion is on a favorable on Senate Bill 270. We've had discussion. We'll do the roll call. The Vice Chair,
Yes.
Delegate Anderson,
Yes.
Delegate Erican,
Yes.
Bartlett,
Yes.
Hardin,
Yes.
Conaway,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Deborah Davis,
Yes.
Juanita Fisher,
Yes.
Griffith,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
Malone,
Yes.
McComas,
Yes.
Moon,
Yes.
Shetty,
Yes.
Cham,
Yes.
Ron Watson,
No.
Williams,
Yes.
19-1. Okay, now we will go to Senate Bill 335. This is a Sidner bill. Senator Sidner bill did not go through didn't go through delegation, nor did it go through a subcommittee. Whose bill is this? This went through, this is Holly's. Holly, can you give a quick, make a quick statement?
Sure.
Bill does?
Yep. So 335 requires non-governmental corporate parties to file a disclosure statement with the first filing in a state lawsuit. The statement, the disclosure statement will identify any parent corporation of the party and any publicly held corporation owning 10% or more of its stock. The bill is consistent with Rule 7.1 of the Federal Rules of Civil Procedure.
I have a motion on the bill.
Favorable.
Motion for favorable. Is there a second?
Second.
All right. Motion and a second. Is there any discussion on the bill? Seeing none. The Vice Chair,
Yes.
Anderson,
Yes.
Erican,
This is 335.
335.
I'm a no.
Okay. Bartlett,
Yes.
Hardin,
Yes.
Conaway,
Yes.
Cox,
No.
Crutchfield,
Yes.
Deborah Davis,
Yes.
Juanita Fisher,
Yes.
Griffith,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
Malone,
No.
McComas,
Yes.
Moon,
Yes.
Shetty,
Yes.
Cham,
Yes.
Ron Watson,
Yes.
Williams.
Yes.
16. Last bill, 342, sent to the Civil Law Subcommittee, has to do with the sale of superfluous armories. Buildings that are called armories. Delegate Carton,
Yes.
armory in his.
Thank you. Yes, we do, and hopefully that's going to be sold. This just allows or codifies present practice, which is to allow the other agencies to be able to bid for a surplus real estate before it goes off to the regular clearinghouse. Holly, am I correct on all that?
This one was Claire's.
Yes.
Oh, Claire, am I
That's-
correct? I apologize. Claire, am I
That's-
correct?
Yes.
Okay. I would move favorable, Mr. Chair.
Motion for a favorable and a second. Is there further discussion? Seeing none. Vice Chair
Yes.
Anderson,
Yes.
Erican,
Yes.
Bartlett,
Yes.
Carden,
Yes.
Conaway,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Deborah Davis,
Yes.
Juanita Fisher,
Yes.
Griffith,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
Malone,
Yes.
Comas,
Yes.
Moon,
Yes.
Shetty,
Yes.
Cham,
Yes.
Ron Watson,
Yes.
Williams.
Yes.
All right, that's with 20. That concludes the voting session for today. We will certainly be voting and taking up a couple bills that have come back, it looks like, from the Senate. We'll take them up tomorrow. We will be in committee in between the two voting sessions that are likely to happen. We're likely to have double voting sessions tomorrow, so we'll figure out the time when we get a little closer to time. With that, thank you all very much. We appreciate it. And this has been the House Judiciary Committee. Have a good evening.